because we put it online, and although it's very similar to the conceptual opening words I gave in previous years, there are some...
אבל יש יתרון, זה כמו...
For you especially.
Alzheimer's severe.
It's a good exercise. Yeah. So after our introductory meeting 3 weeks ago, what I want to do today is basically talk about the basic concept, substantive concept of the question, the research question that we are asking here as a center. And you can, of course, attach your individual project to this framework, and I hope that the framework can also assist you in your individual research and shed some new lights, points on the specific question that you are asking. And the original concept of the center was to investigate what happens, and maybe also what should happen, to the rule of law under extreme conditions. And I will also talk about the origin of the question in its modern form in a second. But since the center was incepted, we are witnessing problems or deterioration or even misunderstanding of the main concept of the rule of law as we assumed when we framed our center. We assumed that everybody agrees in the liberal democratic world about what is the rule of law, and that it might need to be compromised under its extreme conditions, but that under normality the rule of law is the rule of law. And actually, since the inception of the center, especially in the last decade, we are witnessing that the rule of law itself is under extreme condition without natural or other extreme condition surrounding the state or the society. So I want to say a few words about the concept of the rule of law itself before I will move to some insight with regard to the rule of law under extreme condition. And what I just said is manifested by last week's report in Haaretz, according to which the Ministry of Education in its syllabus or instruction for teachers in civic studies, Ezrachut, ordered the teachers to disconnect the notion of the rule of law from human rights, or stating, rule of law is one thing, human rights is a totally different thing. And I think that this basically reveals a misunderstanding of what is the rule of law. So in a sense, our project also enrolls backwards in order to try to talk about what do we want from our society, collective decision making and institutions. And if we look at the history of the rule of law as a distinct political idea, it was incepted in the 16th century, and it became a key component of modern political theory, political philosophy, or modern theory of the state. And I will say a few things about what happened before, what was the perception before, which is not the concept, the current concept of the rule of law. The term itself, the rule of law, was coined first by a very famous English jurist, the father of constitutional administrative law in Britain, Dicey, in 1889. And it's interesting that his definition is very relevant to current issues, current affairs, because he said that the rule of law means that no one can be punished or made to suffer except for a breach of law proved in an ordinary court. Okay? Basically, this means a very fundamental right, human right, not to be sanctioned, not to be punished without a due process of a rule of a court of law. So here is, of course, an immediate link between human rights and the concept of the rule of law. Further, he said no one should be above the law. Everybody should be equal before the law, meaning also human right to equality. and that the rule of law includes, this is interesting because the results of judicial decision determining the rights of private person, because it also relates to the current debate about the role of the judiciary, of the courts in Israel and elsewhere. If we look at a more modern definition, which is which is integration of various materials about the rule of law, I think that there are two important factors here, which also will indicate what is the problem or what are the potential problem with the rule of law under extreme condition. One is that every member of the public is subject to the law, negating the idea that some people or rulers are above the law, and this also connects to the shift in political theory between what happened before the 17th century, 18th century, and what happened in the dominant political theory of the Enlightenment and onwards. Before that, political theory saw the king or the ruler as above the law, and one of the revolutions of the Enlightenment and the foundations of modern liberal democracy is that we are all subject to the law, also those who we elect or appoint to very high offices, including head of states. Again, this also infers equality before the law. This is a very important component of the rule of law. A second component of the rule of law, which is maybe even more relevant to extreme conditions, is that governing should be by norms, by laws, by general laws, as opposed to decision on a case-to-case basis. This is the balance between general norms, law, and other legislative or legal actions. And the idea that governing should be by laws and not by individual decisions is that if there are general laws applied to everyone equally, then of course arbitrary governing or decision making will be avoided, because either you are within the norm or not. While if we take the idea that governing should be by case to case or by individual decisions, of course that leaves a lot to arbitrary rule, inequality, etc. Laws, therefore, are the main tool of government, and laws should be, of course, clear, prospective and not retroactive, published to everyone with the element of generality, etc. These are the two, I think, main foundations of the rule of law, and the rule of law doesn't require democracy. It has required election. What we are witnessing today in the world is that the rhetoric of leaders in liberal democracy, or countries that used to be liberal democracy, is that, we were elected, this is democracy, now we are in office, we can do whatever we want to do, and this election is not actually a component of the basic notion of the rule of law, and there are some countries in which there is no election, but rule of law is maintained quite efficiently or quite successfully, for example, Singapore. What it means, if we talk about institutions, again, this reflects to current affairs, is that if you want to have equality in front of the law, equal enforcement of the law, nobody above the law, governing by laws, you have to have institutions that will enforce the law on everybody equally. Institutions like the institutions which are now under very fierce attack in Israel, the courts, prosecution, attorney general, etc., and building them in an independent way is a very, very structural component in order to achieve the rule of law. There is another important facet, again connecting rule of law to human rights, is that we have this distinction between the formal facet of the rule of law and a substantive facet of the rule of law, which basically mean what is the legal position. And in this sense, we can talk about legal philosophy, but Barak, when he said everything is captured by law, law has an answer to every question, human question, is right according to this analytical framework. The rule of law from a definitional perspective, the formal facet means that we individuals who comprise society are free to do whatever we want to do unless there is a clear law that prohibits us to do something, while non-natural legal persons like institutions, government, any institution which is has powers, does not have any power to do something unless they are granted to this institution. These powers are granted by law. The legality principle, if you want, in administrative law or constitutional law. And this means, by the way, the two facets mean that really every human interaction, every human action is covered by law. Either there is freedom of the individual to do something, or the individual is prohibited, or either the agency or the government or the institution has power, if not power granted by law. If not, it doesn't have this power. But this formal facet is not sufficient, because under this facet, governments, legislators can enact laws that prohibit everything to individuals or give extensive or unlimited powers to various institutions, and therefore we have the substantive facet in which we want to review laws limiting individual freedoms, as well as review laws granting powers to state organs if they exceeded the social contract, the constitution, human rights. Here also there is a very strong link between human rights and the rule of law. By the way, I don't want to talk an hour and a half, so it will be good if you protest or remark or compliment I'm not complimenting me, but but add anything. It will be good if we have some interaction. Anyway, why the rule of law is in the focus of interest? Because I think the interesting thing is that various studies, sort of the studies that are conducted in the Minerva Hamburg branch, low resolution studies, found that the rule of law, or the degree of rule of law, or the quality of the rule of law is one of the best prediction to success of a society, both economically and otherwise, happiness of people, and it's not necessarily elections, it's not necessarily economic condition, but the rule of law, which of course there is correlation between these factors and the rule of law. And there are, maybe this will be relevant to some of your research, two main indexes that are attempting to measure the rule of law in different countries. One is the World Justice Project, that includes 113 countries. Israel is not covered there, but you can see that in the top of the table you'll find, not surprisingly, the Scandinavian countries, Denmark, Sweden, Norway, North European countries, Netherlands. One can see anything there? Hardly. And in the bottom of the table of the rule of law, this is actually more surprising, but see it myself. Yeah. So can you? What are the countries in the? No, that. But I think we said.
Top to bottom?
Just stick.
Zimbabwe, Ethiopia, Pakistan, Uganda, Bolivia, Bangladesh.
Elliot, we asked for some interaction. My question is whether the research, those research that were done, say that the rule of law is in a good situation in a successful country. Is it because the rule of law makes it a successful country, or a successful country can have a good rule of law mark?
Yeah,
So
there is.
Is it the cause for that, or is it just the symptom?
It's a valid question. What is the causal connection between the rule of law and success, whether success brings the rule of law or otherwise? Of course, the indexes are meant to imply that a good quality rule of law brings or is causing success in other fields like economic prosperity, people's well-being.
Problem with the law resolutions.
Yeah. Yeah, but and of course, on top of that, you can question how the rule of law was measured. Okay, what were the criteria? You can see here some of the criterias.
They include fundamental rights.
Huh?
The previous slide said they include fundamental rights.
Include
So
fundamental rights. So this is from an analytical perspective, a tautology. If you measure the rule of law by the degree of fundamental rights, yes, yeah. These are all valid criticism, but I think that the picture is interesting because you can also watch different patterns of countries. And I just came back a few days ago for a very short trip in South America, among which 5 hours and a lecture in Buenos Aires. I don't know if you've been to Buenos Aires. It's a beautiful city, amazing city, you know, very different from other cities in South America. You see there, it's a combination of Paris and London and Washington and New York with really very, very nice layout. And I looked a little bit about on the history of Argentina. In the 1920s, Argentina was equal power to the US and economically and culturally and the question of how it deteriorated. It's now a horrible crisis, both political and economic crisis there. There is a new government which is the Peronists, and they have horrible economic situation. The law faculty in Buenos Aires is a building that looks like the Pantheon. It's from the outside you think it's, you know, there's no such building in the whole of Israel, but when you go inside and everything is deserted, no library, no books in the library, no furniture. It's really quite striking. Argentina, well, I think one of the theories, and this is connected to your question, is that lack of rule of law and corruption, which we'll see is connected to a lack of rule of law, deteriorated Argentina from the potential of being the main power in the world, and to the state that it is today.
Several decades of military rule. Several decades of military rule.
Yeah,
Vast violations of human
but
rights.
yes, but this is connected to the lack of rule of law that preceded these years and the capture of the government by the dictators is connected to that the rule of law allowed, okay, that there were no institutions that actually prevented such a coup d'etat or dictatorship. Yeah, we were also, during these 5 hours, in the site where they actually tortured and killed a lot of dissidents, among them, by the way, quite a few Jewish dissidents. Anyway, this is the table of the rule of law. This is kind of a map of the degree of the quality of the rule of law, where you can see that Europe, North America, Australia are basically with a strong rule of law quality as opposed to the other parts. The gray areas are those countries that were not included. There is another index in which Israel is included, the World Bank Rule of Law Index. Actually similar results to the World Justice Project. You see where Israel is?
31.
31.
33.
Of
sorry.
33, yeah.
33.
33, and if we compare it to the index from 2016, Israel was 30, if I'm not mistaken. Yeah, we dropped 3 places, which also, by the way,
Out of how many is this index?
this is the whole, all the countries in the world. 33 is not a horrible ranking, but of course it's after the liberal democratic first.
It's including the West Bank.
Okay, the excellent question. It doesn't include the West Bank. Doesn't include the occupied territories. Yeah, if you include the occupied territories, then I think we will deteriorate more. But it's interesting that what happened in Israel between 16 and 18 brought this jump or deterioration of 3 points. When you think about it, all the initiatives of the government to change the composition of the court and change the way the judges are elected, and of course cannot be manifested in the index because most of these initiatives are only on the table and were not legislated. So maybe
What about corruption? Government corruption?
no, but fundamental the index is comprised of various indicators like fundamental rights, the strength of institutions, judicial independence, and stuff like that. So these are, only the result of what already was legislated or was implemented. Like, for example, the civil society, the NGO law. I don't think that the basic law Israel as the nation state of the Jewish people is included because the last indicator is from 2018 and the law was not enacted yet. But it also shows the potential, what will happen to us in this index if many of the government's initiatives will come through.
But is political corruption not one of the criteria?
Yeah.
I mean,
Yeah.
it is. Okay,
It
so
is.
maybe that could also explain it a little. No, of course, he wasn't indicted. Actually, the prime minister wasn't indicted yet, but maybe.
Again, the
There were
question,
other
how did they
ministers,
measure
yeah.
political corruption? By the way, measuring political corruption is not so simple because in the very, very sophisticated countries, you don't even know about the corruption.
But there is an index for
There is an index. By all these indexes, I'm saying, there is an index that is based on self-reporting or people's reporting or experts reporting. From a scientific perspective, to have an index of corruption is very problematic. I always say, that the 3 degrees of corruption is the first degree is that some people act officials outside the law. A second degree is that for benefit of society, let's say, of causes. A second degree of corruption is when people actually act against the law for their own interest. And a third degree is when the institutions that investigate corruptions cannot investigate it properly or cannot enforce it properly. And we are not in the highest stage of corruption. Because so far, I would say, again, we can debate about it, because there were affairs in which politicians maybe should have been indicted and were not indicted, but I think that generally, again, it's not a populist vote, but I think experts' vote would say that we have institutions that once they are investigating corruption, they are doing it partially and neutrally and objectively in general. There are, of course, exceptions to that, or margin. In the margin, not everybody is equal in front of the law, even with our very, very impressive institutions.
And another question, why should the nation law affect these students?
Because I think it violates basic rights and the basic notion of equality of citizens.
Effectively, particularly, just a general declaration of differences, but
when they encourage Jewish settlement,
okay.
I think you can say things that the law affects differently different people, for example.
But it's still
encourage
not
Jewish
pointing
settlement.
It's
for
expressive.
It's just
It's the most expressive.
Yeah, but it's a basic law. It should be expressive, and then stuff will be interpreted.
but not yet.
Yeah,
I mean,
it has been legislated.
There are some basic, there are some articles in the law that are clearly manifest inequality or unequal treatment of all Israeli citizens, and are not only expressive. For example, one article which was not under the heated debate, it's not a language thing, a language, they aggregated the Arabic language, but there is an article that says, I forgot its wording, but the state of Israel will help assist Jews abroad who are attacked because of their Jewishness, and Israelis abroad who are attacked because of their Israeliness. Okay? Now, when you think about it, it means that if there is a terror attack against Jews abroad or Israelis abroad because they are Israelis or Jews, there is a duty of the state to help. If there is attack against Israeli Arabs abroad because they are Muslims, because they are minority, or because they are fifth column in Israel, there is no duty of the state. Okay? This is, for example.
Does that really say that? I mean, when you're abroad as an Israeli, they're probably being attacked because they're Israeli. I mean, there's a lot of...
Yeah, but if Arabs are attacked abroad because they are Muslims, okay, not because they're Israelis, because they're Israeli Muslims or because they are Muslims, then the state does not have a duty to assist them. Now, very interesting, we can talk about the law. There is also a very interesting clause that also was not discussed publicly, saying that Israel will, this is also inequality, but not, I don't think that the inequality here is the main feature of problem of inequality is between Jews and not Jews. Israel will help or will assist or will try to cultivate Jewish communities in the diaspora. This looks very nice. What does it mean? It means that in the diaspora it's okay not to be Orthodox Jew. Okay? It's Jewish communities for all dominations. Okay? Conservative, Reform, Orthodox, Liberal. In Israel, it says, that this duty of the state of Israel to cultivate and to support Jewish communities only in the diaspora, not in Israel. It means that the state doesn't have a duty to support those Jewish communities in Israel which are not identifying themselves with orthodoxy. So there are a lot of hidden things in the law that can refer to actual inequality. I don't have any idea how these indexes will incorporate such a law, will score, you know, it's done by people, individuals, researchers, and depending on the reading of the law. This is also something very important for, you know, our research community, that in order to measure something, this is low resolution. The indicators are very, very thick, and you really cannot delve into the details and how the law operates on the ground. That's the reason that we, you know, wanted to do research in also a mid-resolution and a high resolution, in which we delve into not only what the law says, but how it is applied and what are the practices on the ground. Okay. Let me talk a little bit about the rule of law. Yeah, Shelley.
In the United States and what's going on with Donald Trump and the Mueller report and stuff like that, do you think it will influence? Because you can see that, like you said, the mechanism that should be overlooking governmental actions are being a bit maybe compromised?
It should, I think. It's interesting to see, where is the US in 2016?
19?
19. And in 2018?
15.
Here, 15.
It went up.
That's the Obama administration.
Yeah.
That's the end of the Obama administration.
The
leftovers, at least.
when was Trump elected?
2016.
16.
No,
but-
it actually went up during the Trump. That's very.
I don't know,
No,
it's
it
still.
went
First couple of years are
15.
not the new president.
You have to actually check the mechanism.
All these indicators, of course, you know,
Wait, 19, I mean,
No, it was 16.
16 they were
16
lower
and
than
18 were
18.
lower.
wow.
But, you know, this,
It's not that strange. It's a World Bank.
Problem with low
It
resolution
looks at
research.
things like ease of doing business and government transparency, and the Trump administration did all kinds of things with eating tax for companies, etc. So that feeds into the index as well.
or that, you know, even 2018 index is based on measurement of 2007. And it really doesn't show the Trump effect yet. We'll see what will be the 2019 or 20 index. And again, and this relates to the question how you measure and
Yeah.
what. When you think, if you look at the legal output of laws enacted during Trump, I don't know if you know, Trumpism is really revealed in the actual formal outputs of society. I don't understand the American system anyway, because it's not, the American system doesn't have the basic notion of a rule of law in its structure. Okay, you know, we in Israel are socialized to incorporate Kelsen. Okay, constitutional norm, law cannot violate constitution, regulation cannot violate law, right? We have a pyramid of norms, okay? And this is a very, very important paradigm for us to analyze and evaluate. I don't think that in the US they believe in it, or they practice it. When you can have a decree of the president, right, that actually changes law of Congress, or negates law of Congress. Nobody asks, is this valid, not valid? A lot of debate in the US constitutional scene is federalism versus states.
I mean, it seems
you
like there are
spend...
very few checks and balances, which we actually.
No, it
They do
is...
have checks and balances. They have
No, they
Supreme
have.
Court review over executive. You're right that the executive degrees are very powerful, but they have to be sort of lodged into a rather narrow frame of presidential powers, which is a constitutional doctrine that controls the powers of the president. It's liberal scholars, lawyers, who have argued for widening the scope of presidential powers, and Obama was very powerful through executive degrees also.
Yeah.
But that is something that the Supreme Court is able to review, and has reviewed, for instance, with the travel ban. That was reviewed by federal courts. So
Yeah,
There's another issue with
but the
with
travel
the
ban,
access
you
to-
know,
yeah, to-
nobody talked about whether the president has an authority. You know, the review was on the basis of whether this infringes human rights and so forth. But let's say that a travel ban would stand in the requirements of equality or human rights. The mere power to issue such a decree, not through legislation but through a president decree, I don't know a lot
yeah,
about
I don't,
it.
at least in the legal constitutional scholarship that I've seen, but I don't follow very closely.
Mhm.
There is an issue of discussing what the scope of presidential powers is and how could such decrees be justified. But I really am not an expert.
I don't want to
Yeah.
open a big debate about the US, but if you read American Supreme Court decisions, there is very little law in it, legal analysis. Okay? We all know that judges are not angels, and they have some ideologies, and they they insert them into their decision making. But the arguments, usually, at least in our system, the judges try to construct the arguments in legal terminology and framework. In the US, sometimes you feel it's a political manifestation. And that's the reason that I'm saying that I'm not sure if there is at all concept of rule of law, this sort of style in the US. And it's true that I think the American system success was based on checks and balances, on the fact that no institution has ultimate power to decide, and every legislation can be vetoed by the president and be overturned, and all these mechanisms. And of course, this system works fine if all three branches are independent. But once you have a Supreme Court which is not independent, or once you have for a very long period a Congress which is in the same party of the president, then the system creaks. Again, it's not the topic of the, but just an hour ago there was a press conference with Avigdor Lieberman. He's saying that if you were not updated, that he blames both Gantz and Netanyahu, and he said the solution is to change the system, to have a direct election to a prime minister. And actually, I would say, that our system is very good. Okay? And if we compare it to, first of all, most systems in which there is a direct election to the leader, it's not the US and France, it's these South American countries mainly that copied the American model and totally failed with regard to real checks and balances and the rule of law. And if you look at Britain today, Britain, you don't have a direct election to prime minister, but you have a system that a lot of us in the past thought about that it should be much better. The first past vote, a representative who is elected by a constituency, small constituency, is responsible. There, the crisis in Britain is because there are only two parties. Our parliament, what we can say, represents the opinions in society almost like a mirror picture of society. And in a sense, we can do without a government that in any specific topic there is a majority and minority. And had we would be governed by the Knesset, okay, there would be a vote about public transportation on Saturday, and there is a chance that most of the Knesset members will vote in favor. So every question can be answered, and it will be fair because the parliament really represents society like a mirror picture. And so every system of government has its advantages and disadvantages, and in a sense I don't think that our system of government is inbuilt for problems vis-a-vis the rule of law. On the contrary, but this was only a side note. So, the rule of law under extreme conditions. The question really came to public attention following the various responses to 9/11, various legislation and other acts that were taken by liberal democracies or countries that are categorized liberal democracies, like the American Patriot Act, the Prevention of Terrorism Act in the UK, which brought to the surface a debate or theoretical criticism from the 30s, Carl Schmitt, who actually said, you know, if everything is nice, that you have a rule of law, institutions, decision making, but in time of emergency, this rule of law is abolished and all of a sudden the government or the president or one power can decide everything, then there is no liberal democracy. The sovereign is the person who can switch, turn the switch from normality to extreme conditions, and the whole idea of liberal democracy is basically false. And this criticism was actually taken by Agamben in 2005, addressing the responses of liberal democracies to 9/11 and the threats of terrorism. So this, I think, was the starting point of our journey, and the increased research in the question of the rule of law under extreme condition. And when we talk about extreme condition, we talked about it already last time. We talk about not only security threats, terror, wars, but also, of course, on disasters, man-made and natural disasters, and as well as economic meltdowns and political meltdown, which, of course, brings a core question of if we justify some kind of a change or switch in the rule of law during extreme condition, what tests should be conducted in order to constitute or to decide that there are extreme conditions? Because, as you see here, you know, the security background extreme conditions can range for a total war. All of a sudden, Israel is attacked by missiles from Iran everywhere. The whole population is affected. No question that these are extreme conditions. To minor terror activities, stabbing in Israel, or I would like to give this example. You know, the Boston Marathon, which in Israeli terminology was a very small terror attack. You know, there was a little bomb in a basket, yes, killing 2 people, right? We would not consider it as something that should change the whole structure, and people in Boston were in curfew imposed by special decrees for 3 days or 2 days. 2 days. The whole millions in Boston, because it was regarded as total extreme conditions in the US. So this is a very important question, a key question, because, you know, if we believe in some kind of a justification to switch the rule of law to a different regime under extreme condition, who decides if we are in extreme condition is a very, very important question. And as we know, every individual encounter extreme conditions personally. If our house is flooded, if our house is burglared, we feel that it's the end of the world. When does these events constitute a real extreme condition? And we have this will be basically my conclusion at the end, that I think that we should distinguish between three situations. Normality, and of course the law, under the regular normal rule of law, should treat abnormal or small extreme conditions. We have police forces, we have various powers of Shirut Kabaut and various other things that are meant to treat irregularities in normality. By the way, from a philosophical perspective, there is no such thing as normality. Every second is different from the former second. But a good legal system has powers, duties, institutions to regulate small anomalies. Then we have a real state of emergency in which there might be a justification, I will talk about it in a second, to change some components in the rule of law. And we can also think about a total exception, okay, that a situation which was not predicted and is really imminent, in which even maybe the mechanisms to regulate extreme conditions or emergencies are not sufficient, but this is the core of the debate. And I would say that from vis-a-vis the rule of law, the important characterization of an extreme condition that merits a change in the rule of law depends on the magnitude of the irregular conditions. Again, a flood in a house or in a neighborhood or even in a town might not create extreme condition. A flood that actually in Venice a few days ago, hope that you've been to Venice once, because it will not be the same Venice anymore. The magnitude, the population spread, and the imminency of the extreme conditions and their predictability. I think there are these four very important factors. Global warming, it's a huge threat, I think, on the world, but we cannot relate to this in this framework as extreme condition, because it's not that tomorrow everything will collapse, right? Even according to the most pessimistic scientists, we still have 50 years or 70 years, right, Deborah, to prepare for it. So there is no reason for dictatorship in order to confront. So the imminency is a very important element of extreme condition. And in a sense, these features are also echoed by legal texts. Countries, who are signatories to human rights treaties, these treaties have usually a clause that says that if there is an emergency, they can declare derogation from their commitments for the time of the emergency. And the court, in this case the European Court of Human Rights, said that derogations are legal, are valid, if an exceptional situation of crisis, of emergency, affects the whole population, constitute a threat to the organized life of community of which the state is composed. Okay? So these are part of the components that I mentioned before that constitute extreme conditions. I think that the difference between extreme conditions, state of emergency, and the exception is really the predictability. Okay, because if you predict, now we predict that there might be a comprehensive missile attack towards Israel. If this happens, it's not an extreme condition or an exception. Okay, because we know that this in certain degree of probability can happen.
What would you
It-
say about an earthquake, which we know by a certain degree of probability, but we have absolutely no real idea that it happens every 90 years, a severe earthquake. So since we can predict it, it's not an exception.
It's not an exception. We are not preparing ourselves well,
Yeah.
but it's not an exception because we know that this happens once every 100 years, that
Right.
this will happen very soon. And we know also the consequences of,
Yeah.
you know,
No, we have
the consequences will not be destruction of everything, right? Even
Depends, no?
Predictability is a bit
Depends on the
subjective.
extent.
Like,
could be 7,000 people. If we look at the same, seven on the Richter scale, they're talking about.
When are we anticipating that, just
Now.
for general knowledge?
today.
What?
When are we anticipating this?
Today.
Now.
Any day now.
Any day now? Oh.
It was
Statistically.
1927. It's about time.
the
Or
last,
it was 1837. It was 1837, then 1927.
Wasn't every 100 years?
90 years.
90.
90 years?
It was 90. 1837, 1927, and we're a couple of years past. We're 92.
during the earthquake in 1927, my grandmother, grandfather, and my father was a small child, visited friends in Hebron. And they had very, very good connections with a lot. My grandfather had a hospital together with an Arab doctor, and they had a lot of friends, and the earthquake happened. And then the friends of my grandparents said, quickly, go out from Hebron, because the local people will come and will blame you for the earthquake. It's interesting,
Yeah.
I didn't think about it by Praot, 29, maybe I'm
You
not
think
gonna.
it's-
But how many people were
I
killed
don't
in 27?
Well, less because it was much less densely populated. I mean,
Yeah.
but quite a few. I mean, a couple of hundred.
Okay.
I mean, not.
But whole
I have to
cities were
look that up.
destroyed, no?
Yeah.
Tibera were
Yeah.
destroyed.
Destroyed, what does it mean destroyed? That all the houses were.
Yes.
See, the difference
I don't think that
is,
had this.
Most
A
of
lot
them-
of people.
most of them were. The difference is that the building was sparse. I mean, now you're looking at much larger
Yeah.
destruction because
It's more
our density, the urban, is uncomparable.
On the other side, a lot of buildings are.
Now, in Haifa, for instance,
Yeah.
80% of the buildings don't reach the standards of 1980. They've been built before 1980. And even those standards of 1980, it's not really clear, in terms of, sorry. Anyway,
No,
it's
it's
not good.
this is.
No, I look at
Any idea where exactly it's going to hit? I mean,
We're in
in Biafra?
Yes, not in Tel Aviv where Tama 38.
Not in
You
Tel
know.
Aviv, really?
No, you're good at
Haifa.
Shlomi. Oh, so it's not.
The
Oh, okay,
No, it's
okay.
like
so-
Otef.
Kill them all.
I see.
Um,
No, I'm just, I had no idea that it
we're
was
right on
anticipated.
the
fall.
Jordan Rift
You
Valley.
Right on.
helps.
Haifa is under it. Huh?
Mamad
Wow.
helps.
Well, the Mamads were built after 1980,
Yeah.
so yes.
Yeah, Mamad, Mamad will help if you are in a
Yeah.
Mamad.
Sure, no, and the
Hopefully.
building standards changed in 1980. Any house that was built after 1980, yes. it
Subject
helps
to the
a
level
lot.
of corruption.
And subject to the inability to actually supervise we actually don't have the
That's the third
Basic
level of
knowledge.
corruption. according to-
So, some of it's not even corruption, it's just, but anyway, those people who live in houses built after 1980 have a better,
Chance.
Better chance.
Better
chance.
survival.
invite your friends.
I would say
How long before we know?
Smaller shakes?
No.
Very little.
Very little.
When your dogs behave strangely, that means that an earthquake is coming. And some people say that they.
That means
This
that
is why
your
you
dogs
have to
never
dog.
behave strangely. What about dogs that always behave strangely? I mean,
Who
that's
knows?
fine.
What about people
But-
who behave?
When the birds disappear.
I would ask whether I would question or thoughts about the unpredictability issue, whether it's whether it's the question with whether it's a state of emergency, some kind of more subjective issue or objective. Okay, so it calls for that question. Whether if the way that people are grasping the situation is one thing. So it can be totally predictable, but like an earthquake, but when it happens, it's terrible. So, and there's a question, I think, whether we are how are we measuring whether you're putting in subjective issues in it. I personally, my first thoughts when saying that was that it can be the unpredictability. It's not even a test. It's more like something that can contribute, can help the other deciding on other issues, because unpredictability, you can have a very terrible situation like an earthquake, like where it's totally predictable in a sense, and still have to derogate in order, the country has to derogate from some standards that it usually holds in the situations to deal with it. You have to stop all people from moving from place to place. They have to maybe get all the police, get everybody out of the streets, and other measures that would not be like usual. That will have to just draw the situation. So my thoughts were completely different than yours on that. I thought that unpredictability is something that can contribute to understanding of the situation, whether it goes to an extreme or not, but it's not an independent factor.
None of these factors are independent. And I think that this is a very, very good point, because the borders between normality, emergency, and exceptions are actually affected by the quality of the government today and preparation. Okay, preparation also from a perspective of information to the population, and of course in poor rule of law, corrupted countries, people don't prepare for anything. So of course everything can be regarded as, let's say, in the club of countries that Israel belongs to, let's say the first world, there are political economy obstacles for real preparation. Okay, because for example, earthquake is the best example. Because if you take into account, my field is law and economics, that's where I come from to all this, and if you take into account political calculation of politicians under a very rigid model, politicians interested to be re-elected. Under a more moderate model, politician is interested to benefit society but is constrained by the consideration of election. Everything that is more than 4, 5, 7, 8 years doesn't interest the politician, because he or she knows that this is behind our cycle, and this is the once in 100 years, even if we are getting close to there, is not of the interest of politicians. By the way, this
it's not
is
in the memory. It's not in our collective memory. When you talk about places with hurricanes and with terrible earthquakes that have just happened, then the priorities are much different, because it's both in the community's collective memory and it's in the politicians' collective memory. But when you're trying to prepare for something that's not in the collective memory, even if you know that it's, going to happen, then it's not on either the public or the political agendas, and it's always a question of priorities.
Right. And this relates to the question, how do we extend the cycle of looking at things? And we have institutions that can be explained, again, from my very narrow perspective of law and economics, that were designed to have calculations which are beyond the political cycle. For example, central banks. The whole idea of a central bank, which is an institution, independent institution, setting the rate of interest, which is a very unpopular, usually, decision, looking for a longer term than the political cycle. And rational politicians will be interested to have an independent central bank, okay? Because in the long run, it helps the politicians as well. They can blame the central bank, as Trump is doing to the Fed and was done also in Israel. So it's very nice from a political perspective to have been able to claim the credit for economic success and shift the blame for unpopular decisions. By the way, this is the economic analysis of independent judiciary. Why should rulers, rational rulers, maintain an independent judiciary? Exactly for that reason, that if you have, you're babysitting, it's not exactly the babysitting, but it's delegating powers that in a way that you can blame the court for unpopular decisions, but you can take credit for the basic achievements of the fact that we have an independent court, and therefore our economy is better because people are not, inhibited from investing in Israel, because they take, in other countries in which you don't have independent judiciary, people don't invest because they know that once the government is interested, it can confiscate everything. So there is an interest in the same way to have an independent judiciary. Why is it important? Because I think that I didn't meant to talk about the Israeli situation because Amnon said he will give us a separate lecture. But this is exactly the key issue with regard to emergencies in Israel, that we had a real independent agency, institution, to prepare for emergencies, institutions that is not dependent on the political cycle, expert, Rachel, this was the idea of Rachel, that it's not political, but this is not the this is not the reality, of course.
That's not the reality.
Yeah, but if you have such an independent agency, okay, then this agency will be able to derive, to make decisions that are unpopular and not contingent on the political cycle or the next election. And I think this is a very, very problematic component of our extreme conditions preparation. Okay.
I fully agree with that. There's something to add, I think, for the issue of subjectivity, which is very important. It comes out very densely from our research now, is the fact that the understanding of the people grasping the situation there's a lot to do and to check on the what we call chosen, the ability of the resilience of and actually what they're saying to us, people that we are talking with, is that the more resilient the population is, the less they will need to be in an extreme situation, to derogate into, to have the problem can be contained more easily. Even it goes directly to the need to go to a state of exception.
So in Sweden, 1 or 2 months ago, every citizen was given a little handbook how to prepare and what to do in case of simple, not the investment of huge amount of money. Here, chaplap.
I think Haifa prepared a booklet.
Yeah.
Yes, I believe. I don't know, anybody live in Haifa? I think I got a copy. I think that Haifa prepared a booklet for every household.
And then it got burned in the fire?
It wasn't in the booklet.
Mm.
It was about earthquakes.
Our former dean, in our we had a special one-day conference on the fires in Haifa. He lives in a neighborhood in which I think 15 or 20 people.
Remez.
Hmm?
In Remez?
No, in forgot the name. Hmm? Not Denia, but down Freud on the right. Anyway, about 10 houses were burnt down there, and he said our house was not burned down because our Vad Bait is this annoying guy that stick to the rules. They're supposed to be, according to the regulation, every house has to have a
Sprinkler system,
Mm,
certain
yeah.
Yeah.
And he kept this, and he nagged everybody not to block it and not to that, and it operated, and they saved the house. But if there is a guideline, a booklet, enforcement of this by inspectors,
No enforcement.
what?
Problematic.
Hmm?
Enforcement is problematic.
Yeah, also.
I wanted to ask about this division that you proposed between normality, state of emergency, and exception, whether you see them as three distinct categories or as more of a spectrum with some overlap. Just like two examples that came to mind. For instance, in terms of emergency, so you have this criteria of unpredictability, but going back to what you said about countries that are sort of accustomed to certain types of emergency, for instance, I have relatives who live in St. Thomas. September is hurricane season. Hurricanes cause huge damage there. It does, they do cause a lot of these criteria of emergency, but they're very predictable. They're like, okay, it's, we have to, they usually travel in the summer. September begins, we have to go back to St. Thomas, we have to do this and that, and things that are very sort of, and they deal with this emergency in a very sort of predictable and calm and almost normal way. And of course, maybe even a better example is the state in Israel, the state of emergency here in Israel, which is a permanent state, and really seems, if you look at these categories, seems more sort of in sync with normality in a way than with a state of emergency in this way. Would your response be, this is not a state of emergency, this is the wrong way to think about it, or would you say it's a sort of somewhere on the spectrum?
Include the West Bank in this category?
Sorry?
Can you include the West Bank in this category?
Of course, yeah. Well, of course, and the West Bank. I mean, for instance, this ongoing occupation that's not exactly
Permanent.
a war, and now we're thinking about it in sort of more permanent ways and managing it instead of So that's of course also a good.
There were two questions here. One is related to Robert's, the question of subjectivity and how do we define. And I think that it's also, it's not an absolute, it's a relative definition. Country that is used to floods or hurricanes. Then a hurricane there is not an exception. Okay? We are not used to hurricanes.
Look at Bibi's definition of an emergency. That's subjective.
But we are used to terror attacks.
Somewhat politically motivated, I would say.
Quite subjective.
We are used to security threats, and therefore the same magnitude of terrorist attack in Israel should not constitute emergency. And that brings me to the second question. I think the declaration of emergency in Israel that is enforced since the establishment of Israel basically means that our normality is a normality emergency. I will talk about in a second about these models. These models overlap. Yes. I think it's not justified, even if we take into account the West Bank and the occupation, and it's not we are in a very, very bad company of countries in which there is almost an eternal state of emergency. Okay? It's not, by the way, and it's stupid because there is no really usage wide, broad usage of what the state of emergency in Israel, the declaration enables. It, it enables the government to decide everything, to bypass the legislator. Since the court interfered, takanot shat cherub, and all this, there is no justification. And when we asked, this also was a conference that we had a few months ago, about 70 years to the state of emergency, the conference that Nadav Dagan arranged, and apparently one of the speakers from the Attorney General office said, "You will be surprised why we don't abolish the state of emergency." You know why?
Administrative detention?
They are preparing a law that will change. The Counterterrorism Act that was valid only in state of emergency was re-legislated and now valid in time.
Replaced a lot of the
Administrative detention is also going to be transformed.
normalized.
But the real reason, the one thing that they cannot actually agree upon, קשור לזה.
Basic law human dignity?
No.
No?
What, strikes? Labor strikes?
Yeah.
צווי ריתוק.
Okay.
You can enforce people to work only under declaration of emergency, צווי ריתוק. They approach the Histadrut in order to say, we want to abolish the state of emergency, we want to therefore legislate a law that will enable in certain circumstances to enforce people to work. Histadrut say no way, leave the situation as it is.
That was amazing.
Yes.
Just one thing to add in response to your comment is there's a recent book by Michael Sfard and Ona Ben-Naftali and David Turbo, whose basic thesis is that the territories are the quintessential state of exception, according to Schmid and that. Like the place where law is the ultimate tool for the ruler, but it does not constrain him at all. It's very interesting.
Who wrote it?
Ona Ben-Naftali, Michael Sfard, and David Turbo.
We had an event on
Yeah, we had an event and it didn't here. Okay, so let me talk a little bit. I will skip. Why there is, from a normative perspective, justification to compromise on some features of the rule of law in a state of emergency or under extreme conditions, okay? Because we cannot govern by laws only. We have to do special decrees and special decisions which are case to case, by case. And a very important issue is that our democratic theory, and I will not go into the real philosophical foundations and stuff like that, but our democratic theory promotes deliberation, a lot of deliberation before reaching decisions. 3 readings in the parliament, or in other systems 2 houses of parliaments, and this all is meant to promote deliberation, that decision making will not be just technical majorities or representative or others, but, and of course in an extreme condition, a very important feature is to decide very, very quickly. Okay, so I think also from the formal and substantive facets of the rule of law, one can say that there is a justification to limit more than in normal times individual liberties. You impose curfew or you prevent people from entering places. You have to give more powers to the authorities, and you have to also, in a sense, scale down the review proportionality might be working differently, or deference. One of the insights in Israel is that because we are in a constant state of emergency, the courts do perform judicial review. In other countries, the US, if there is an emergency, we don't touch, from Karamazov to Guantanamo Bay. Not only that they change their criteria for review, they say, when the guns fire, the sirens are silent. And this is the unintended consequence of our situation, that because we are in a state of emergency, the courts do perform, but of course they do it by different criteria that they conduct review or the substantive criteria in regular times. And now I get to Rotem's question. I think that conceptually there are three possible models to deal with extreme conditions, and in practice no country in the world has one of these models. All of them have combination of the three models, and the question is what kind of combination, what kind of emphasis. Okay, one model, the oldest model, is the Roman model, or emergency constitution model, or declaration of emergency according to our basic law, the government. Okay, the model means that we have a mechanism that once there is a state of emergency or extreme condition, somebody switches the regime to a regime in which the government has more powers, people can be more limited, and so forth, so on. The Roman model was a very extreme example of that. If the Republic encountered the threat of war, there were, by the way, in the Roman Republic, a very, very interesting mixture of institutions. It was not a democracy, but there were checks and balances, and Senate, and then the Senate elects a dictator. That's the origin of the word dictator. The dictator can do whatever he wants to do. It was always he, I'm afraid. Is not bound by anything, but after 6 months, the dictator has to step down. It was a very interesting model in the sense of separation, individual separation. It was not the same people who are conducting emergency, and so there was no option for the dictator to make decisions that will affect his political career later, because after 6 months he had to go home, and 6 months return to normality. The model worked well. 500 years almost of the Roman Republic, 30-something years were state of emergency. If you compare it to Israel today, it's a better result. This model was copied in modern constitutions. Of course, the weak point here is who declares and who can declare back to normality, and this model suffered a great drawback with the Nazis' rise to power that were basically based on declaration of emergency. Therefore, after the Second World War, countries used it less. German constitution is very interesting because there was no emergency constitution in the basic law of Germany in 1949, but they added it in 1960, but it's a very, very minimal emergency constitution. This is one model. Okay? A second model that is advocated, by the way, by some important scholars like Eyal Gross, is that don't come to us with all these niceties. In extreme condition, operate outside the rule of law, and there will be a assessment after we are back to normality, an assessment whether this was a legitimate step outside the rule of law. And of course, this can happen only in countries in which kind of accountability or election or democracy in which the rulers can be held accountable can work. But this model actually operates on many levels, including the international law, international relations. Third model is the model that denies basically the idea of we cannot predict, we cannot prepare, business as usual. We can actually ex ante, in this first model, arrange for both substantive and procedural rules ahead of the emergency, and this is the normality in a sense, which is problematic because I'm not sure that we can envisage everything, and of course then it means that the substantive rule of emergency becomes actually normality, and there are many other. I just mentioned it very briefly. One can do a lot of account for disadvantages and advantages of these models. By the way, in international law, laws of war are basically business as usual, in a sense that they are prepared in advance, the substance of the law, and the application of the law is according to the situation. Derogation can be attached to the second model, the emergency constitution, and the practice of international law has a lot of examples in which countries operated outside the legal regime. If it's the Iraq war that was bypassing United Nations Security Council, or even the ex-Yugoslavia intervention, and apparently the world community decided that these were legitimate, most of it, at least the Yugoslavia case. I don't know, Iraq cases may be more controversial. In retrospective, approved the stepping outside the rule of law. It's interesting that the rhetoric also is an important part of the distinction between these three models. Both France and UK were under series of terrorist attacks in the second decade of this millennium, and the rhetoric was very different in both countries. In the UK, this is the rhetoric until today, the discourse is about new normality. And indeed, in Britain, there are laws, various laws. Some of them, by the way, are more extreme than our administrative detention law, which enable the authorities to target people, not to kill people, but to specify people and then either detain them or keep them in house. And these are all laws that are not contingent on any declaration of emergency. It's a change of normality.
New laws or?
New laws, yes, from the last decade. Counter-terrorism law. In France, the discourse was totally different. We are in a temporary extreme condition. A lot of measures were applied in the French constitution, and this also is the question which model you classify the French constitutional structure. It says, Article 16 of the Constitution says that in times of emergency, the president has unlimited powers to do whatever he thinks is necessary to do. He has to consult, consulting the Prime Minister, the President of the House Parliament, and the Constitutional Council, but it's only consulting. So would you say this model is stepping outside the rule of law because the unlimited power to one person, the president, or that it is the emergency constitution model, according to which in emergency the president has unlimited power, not more power, but unlimited power. It's an interesting question because if we talk about these powers of the French president that are prescribed by the constitution, okay, you can also talk about the concept of prerogative powers of the president of the US, which are not specified in the constitution, or the prerogative powers which are not really used but exist in theory in the UK. Okay, it's very nice that we have laws and parliament, but the Queen basically, if she thinks necessarily, can do whatever she wants to do using prerogative powers. By the way, there was a lecture, I think Maya lectured here a few years ago about very interesting debate during the mandate period here, whether the תקנות ההגנה לשעת חירום, the defense regulations were enacted giving a lot of powers, and there was something that the government, the High Commissioner, wanted to do that was even not prescribed, and the question in the court was whether the prerogative powers enable him to do that, and there was a dispute between the judges, if I remember correctly. So even in our context, prerogative powers were mentioned. I would say, to the credit of Israel, is that we don't advocate, believe, at least on the rhetorical level, and I think that also on the actions on the ground, the stepping outside the rule of law model. Okay, while in the US, okay, it's very, very natural that the president does something with no authorities on the basis of prerogative powers. Okay, here we always ask, what is the legal authority or power? And you know, there are things happening, violating the law, done by authorities, but we don't have this rhetoric of, you know, in crisis, the government can operate outside the rule of law. I think I'll end here. I hope that, you know, our basic framework of addressing the rule of law under extreme conditions, is better explained after this presentation, and of course it will be great if your individual works will correspond, relate, criticize, revolutionize this framework. We have maybe 1-2 minutes for questions, but I have to teach at 4. So, comments, protests.